right, so Mr. Boyd, in cause number 26, DCCR 0227, the state has elected to proceed on the lesser included offense of a driving while intoxicated second. And that's from November 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they've charged you with?
Yes.
And then the indictment further alleges that you were previously convicted of driving while intoxicated February 9th of 1984. And is that true or not true?
Yeah.
True or not true?
True.
And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Mitchell? The papers on the tablet, did you go over those with Mr. Mitchell?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, you.
And it looks like the agreement that you've reached is for a 1-year term in the county jail, but that would be probated. You'd be on probation for 2 years. You would be required to have the ignition interlock device for that entire probation period,
Yes.
as well as paying a $4,000 fine. And in addition to that, there is no waiver of the state DWI super fine. That's something with you and the state. Do you understand?
Yes.
And then Judge, just for your,
State would request that certified.
All right, thank you.
and right now he has the handheld blower. He does not have a vehicle that he's driving. So
Yeah,
he does have that.
Okay, so if you're not driving,
Yes.
you cannot drive any vehicle
Right.
unless it has that auto ignition interlock device.
Yes.
If you're not driving, then part of your probation would be to keep that handheld the entire time as
Yes.
well. All right. And you're a US citizen, correct?
Yes.
State tenders number 1.
No, Judge.
It's admitted. Any evidence that Mr. Boyd is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, driving while intoxicated second. Sentence you in accordance with your agreement to a term of a year in the Jefferson County Jail, but probate that. You'll be on probation for 2 years. You're ordered to pay the $4,000 fine and to so with the DWI second, it's 3 days. So there's a requirement of 3 days in the Jefferson County Jail by law. Are you working?
Not currently.
So what I'm going to do then, Mr. Boyd, is order that you serve those 3 days starting this weekend. So you will report to the Jefferson County Jail Friday at 6 p.m. You're going to serve 3 days. So you'll get out on Monday. That way you get it all taken care of at one time. It's very important that you are on time, be at our jail at 6 o'clock, no later. Also, it's obviously very important that you show up not intoxicated or anything like that. Some people think it's a great idea to show up and, sleep it off. Don't do that. If you're late, if you don't show up, that's a violation of your probation and you'll be right back in court. Do you understand?
Yes.
Also, I'm ordering that, again, the state's super fee is not waived. The state has requested that, and so it will not be waived. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal.
Yeah.
It's coming. Anything else I need to, I think I said it all. Yeah, make sure you go, if you don't have the attachment. And Mr. Mitchell, you can either email today the attachment, or if you want to handwrite it on something, what you looked at, you can do that as well. But we need it today before we close out the case.
That's fine. I can call Mackenzie real quick and have her send it over.
Perfect. If they'll email it to Ms. Holmes, that'd be great. All right, here's that trial court certification. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork, and she's sitting right behind you. So watch for her to call you up, okay? And again, make sure 6 o'clock this Friday, which is the 20. What's the Friday?
Does he need anything to get in, Judge?
Here, I don't think so.
Okay.
It'll be there.
Okay.
All right. Thank you.
Judge, I'm gonna take him out in the hallway for just a second and I'll go right back in.
Okay, thanks. Kimler, I don't see that you have filed anything that I requested get filed before today.
I didn't understand why I have to file a rule. I mean, it was an illegal sentence. I mean, she never should have received the sentence. They couldn't, the court have the power to vacate the sentence.
No, I don't without a motion.
I filed a motion to vacate the sentence, yes.
I don't see
Really,
it.
that's how it's come, or question.
It's not.
I think there was a
It's
motion.
not a quash. That's not,
There
and
was-
that's why I sent you, and I talked to Mr. Florence, and you said that you were gonna talk to Mr. Florence. And we did all the research, and I've done all the work for you, which is very
All
frustrating
the work, I filed the writ.
before today. And I mean, literally 3 days after court, I handed you on a silver platter, here's what you need to file. You emailed back that you would talk to Mr. Florence if you had any questions and get it filed. So today, what can happen is if you would like to make an oral motion for me to vacate all of the proceedings, I would entertain that oral motion.
Yes, and I think I filed a written motion to vacate along with the beginning of the case.
To vacate or to quash?
But maybe, yeah, I thought of it, it should be to vacate. I don't know, maybe to quash the NTRP. I don't know.
The motion to quash. Would you like to file an oral motion to vacate all of the proceedings?
Yes, Your Honor. I'll move it this time to vacate the prior proceedings in this case based upon the fact that it was not a knowing voluntary plea, since she was pled to what she believed to be straight probation, which was an impossible or illegal plea. And that her decision to enter that plea was therefore based on, I would say, ineffective advice or ineffective information. So it's an
So-
involuntary plea.
So what I can do at this time is grant that oral motion to vacate as a writ under 11072. And so I'm going to grant that motion as treat it as a writ of habeas corpus under 11.072. I'm going to vacate all of the prior proceedings. And so we are now starting at step number 1. And so I'm going to reset the case for an announcement. Ms. Collier, make sure you stay in touch with Mr. Kimler. You need to be back at your next court date for an announcement, and we'll see where we go at that point. All right.
You mind, since you vacated, I don't need a new motion to dispose of this NTRP. It's been.
You
vacated.
shouldn't. It should be, everything should be vacated.
Okay.
And I'll double check if there's anything, but we'll do that. And I need a sticky note on that for an order. And Ken can help me kind of create an order for that. All right, sir. You're Terrence Currington?
Good.
And so, Mr. Currington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right, Mr. Currington was previously in court and cause number 25 DCCR 1114, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have your own.
Yes, Judge.
Any additions or corrections?
Not from the defense.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct? Okay, so here's the thing. If you have that card, you can only use what they give you and the amounts that they give you. Right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
That's not good.
They didn't charge you with it, but they found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it? It is. That's how they give it to you in little plastic baggies.
No, that's, you've seen.
She's asking if the stuff they,
I'm asking you.
is that.
What? Here's the thing. I'm sorry.
He's in the bag. Plastic bag.
Is that how they give it to you?
Um,
Okay,
I put it in there
why would you do that?
for the smell.
For the smell?
This
To block the smell?
right.
Well, if you've got a card, then why are you trying to block the smell?
But I just don't want to be right now. I smell like
Well, how about don't keep it in your car at all?
that too.
That too.
This is one of those moments where the judge shifts from simply approving probation to setting very clear expectations. Notice the focus isn't just on possession, it's on responsibility. The court is essentially saying that having legal authorization doesn't create a free pass. And here's the bigger question. Do you think most people fully understand how strict probation conditions can be until they're standing in a courtroom hearing them?
That too.
This
So here's the thing, having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of your probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork.
And that's where this hearing wraps up. Throughout the proceeding, the judge repeatedly emphasized a common theme. Second chances come with rules, and those rules matter. Whether it's a DWI case or a probation agreement, the court's concern is often less about the past mistake and more about what happens next. What stood out to you most in this hearing?